Rule 139B, Disbarment and Discipline of Attorneys, including Bar Matter number 1645, amending sections 1, 5, 12, 13, and 15 of Rule 139B. Section 1, How instituted. Proceedings for the disbarment, suspension, or discipline of attorneys may be taken by the Supreme Court motu proprio or upon the filing of a verified complaint of any person before the Supreme Court or the Integrated Bar of the Philippines. The complaint shall state clearly and concisely the facts complained of and shall be supported by affidavits of persons having personal knowledge of the facts therein alleged and or by such documents as may substantiate said facts. The IBP shall forward to the Supreme Court for appropriate disposition all complaints for disbarment, suspension, and discipline filed against incumbent justices of the Court of Appeals, Sandigan Bayan, Court of Tax Appeals, and judges of lower courts, or against lawyers in the government service, whether or not they are charged singly or jointly with other respondents, and whether or not such complaint deals with acts unrelated to the discharge of their official functions. If the complaint is filed before the IBP, 6 copies of the verified complaint shall be filed with the Secretary of the IBP or the Secretary of any of its chapter, who shall forthwith transmit the same to the IBP Board of Governors for the assignment to an investigator. A. Proceedings in the Integrated Bar of the Philippines. Section 2. National Grievance Investigators. The Board of Governors shall appoint from among IBP members an investigator or when special circumstances so warrant, a panel of 3 investigators to investigate the complaint. All investigators shall take an oath of office in the form prescribed by the Board of Governors. A copy of the investigator's appointment and oath shall be transmitted to the Supreme Court. An investigator may be disqualified by reason of relationship within the 4th degree of consanguinity, of affinity to any of the parties of their counsel, pecuniary interest, personal bias, or his having acted as counsel to his acting as such investigator. Where the investigator does not disqualify himself, a party may appeal to the IBP Board of Governors, which by majority vote of the members present, there being a quorum, may order his disqualification. Any investigator may also be removed for cause after due hearing by the vote of at least 6 members of the IBP Board of Governors. The decision of the Board of Governors in all cases of disqualification or removal shall be final. Section 3. Duties of the National Grievance Investigator. The National Grievance Investigators shall investigate all complaints against members of the Integrated Bar referred to them by the IBP Board of Governors. Section 4. Chapter Assistance to Complainant. The proper IBP chapter may assist the complainants in the preparation and filing of his complaints. Section 5. Service or Dismissal. If the complaint appears to be meritorious, the investigator shall direct that a copy thereof be served upon the respondent, requiring him to answer the same within 15 days from the date of service. If the complaint does not merit action, or if the answer shows to the satisfaction of the investigator that the complaint is not meritorious, the investigator will recommend to the Board of Governors the dismissal of the complaint. Thereafter, the procedure in Section 12 of this rule shall apply. No investigation shall be interrupted or terminated by reason of the desistance, settlement, compromise, restitution, withdrawal of the charges, or failure of the complainant to prosecute the same unless the Supreme Court, motu proprio, or upon recommendation of the IBP Board of Governors, determines that there is no compelling reason to continue with the disbarment or suspension proceedings against the respondent. Section 6. Verification and service of answer. The answer shall be verified. The original and 5 legible copies of the answer shall be filed with the investigator with proof of service of a copy thereof on the complainant or his counsel. Section 7. Administrative Counsel. The IBP Board of Governors shall appoint a suitable member of the Integrated Bar as counsel to assist the complainant of the respondent during the investigation in case of need for such assistance. Section 8. Investigation. Upon joinder of issues or upon failure of the respondent to answer, the investigator shall, with deliberate speed, proceed with the investigation of the case. He shall have the power to issue subpoenas and administer oaths. The respondent shall be given full opportunity to defend himself, to present witnesses on his behalf, and be heard by himself and counsel. However, if upon reasonable notice the respondent fails to appear, the investigation shall proceed ex parte. The investigator shall terminate the investigation within 3 months from the date of its commencement, unless extended for good cause by the Board of Governors upon prior application. Willful failure or refusal to obey a subpoena or any other lawful order issued by the investigator shall be dealt with as for indirect contempt of court. The corresponding charge shall be filed by the investigator before the IBP Board of Governors, which shall require the alleged contemnor to show cause within 10 days from notice. The IBP Board of Governors may thereafter conduct hearings, if necessary, in accordance with the procedure set forth in this rule for hearings before the investigator. Such hearing shall, as far as practicable, be terminated within 15 days from its commencement. Thereafter, the IBP Board of Governors shall within a like period of 15 days issue a resolution setting forth its findings and recommendations, which shall forthwith be transmitted to the Supreme Court for final action and, if warranted, the imposition of penalty. Section 9. Depositions. Depositions may be taken in accordance with the rules of court with leave of the investigators. Within the Philippines, depositions may be taken before any member of the Board of Governors, the president of any chapter, or any officer authorized by law to administer oaths. Depositions may be taken outside the Philippines before diplomatic or consular representative of the Philippine government or before any person agreed upon by the parties or designated by the Board of Governors. Any suitable member of the integrated bar in the place where a deposition shall be taken may be designated by the investigator to assist the complainant or the respondent in taking a deposition. Section 10. Report of investigator. Not later than 30 days from the termination of the investigation, the investigator shall submit a report containing his findings of fact and recommendations to the IBP Board of Governors, together with the stenographic notes and the transcript thereof, and all the evidence presented during the investigation. The submission of the report need not await the transcription of the stenographic notes, it being sufficient that the report produce substantially from the investigator's personal notes any relevant and pertinent testimonies. Section 11. Defects. No defect in a complaint, notice, answer, or in the proceeding or the investigator's report shall be considered as substantial unless the Board of Governors, upon considering the whole record, finds that such defeat has resulted or may result in a miscarriage of justice, in which event the Board shall take such remedial action as the circumstances may warrant, including invalidation of the entire proceedings. Section 12. Review and recommendation by the Board of Governors. A. Every case heard by investigators shall be reviewed by the IBP Board of Governors upon the record and evidence transmitted to it by the investigator with his report. B. After its review, the Board, by the vote of a majority of its total membership, shall recommend to the Supreme Court the dismissal of the complaint or the imposition of disciplinary action against the respondent. The Board shall issue a resolution setting forth its findings and recommendations, clearly and distinctly stating the facts and the reasons on which it is based. The resolution shall be issued within a period of not exceeding 30 days from the next meeting of the Board following the submission of the investigator's report. C. The Board's resolution, together with the entire records and all evidence presented and submitted, shall be transmitted to the Supreme Court for final action within 10 days from issuance of the resolution. D. Notice of the resolution of the Board shall be given to all parties through their counsel, if any. B. Proceedings in the Supreme Court. Section 13. Investigation of complaints. In proceedings initiated by the Supreme Court or in other proceedings when the interest of justice so requires, the Supreme Court may refer the case for investigation to the office of the bar confidant or to any officer of the Supreme Court or judge of a lower court, in which case the investigation shall proceed in the same manner provided in sections 6 to 11 hereof, save that the review of the report of investigation shall be conducted directly by the Supreme Court. The complaint may also be referred to the IBP for investigation, report, and recommendation. Section 14. Report of the Solicitor General of other court-designated investigator. Based upon the evidence adduced at the investigation, the Solicitor General or other investigator designated by the Supreme Court shall submit to the Supreme Court a report containing his findings of fact and recommendations for the final action of the Supreme Court. C. Common provisions. Section 15. Suspension of attorney by Supreme Court. After receipt of respondent's answer or lapse of the period thereof, therefore, the Supreme Court, motu proprio, or upon the recommendation of the IBP Board of Governors, may suspend an attorney from the practice of his profession for any of the causes specified in Rule 138, Section 27, during the pendency of the investigation until such suspension is lifted by the Supreme Court. Section 16. Suspension of attorney by the Court of Appeals or a regional trial court. The Court of Appeals or regional trial court may suspend an attorney from practice for any of the causes named in Rule 138, Section 27 until further action of the Supreme Court in the case. Section 17. Upon suspension by the Court of Appeals or regional trial court, further proceedings in Supreme Court. Upon such suspension, the Court of Appeals or Regional Trial Court shall forthwith transmit to the Supreme Court a certified copy of the order of suspension and a full statement of the facts upon which the same was based. Upon receipt of such certified copy and statement, the Supreme Court shall make a full investigation of the case and may revoke, shorten, or extend the suspension or disbar the attorney as the facts may warrant. Section 18. Confidentiality. The proceedings against attorneys shall be private and confidential. However, the final order of the Supreme Court shall be published like its decisions in other cases. Section 19. Expenses. All reasonable and necessary expenses incurred in relation to disciplinary and disbarment proceedings are lawful charges for which the parties may be taxed as costs. Section 20. Effectivity and transitory provision. This rule shall take effect June 1, 1988, and shall supersede the present Rule 139 entitled Disbarment or Suspension of Attorneys. All cases pending investigation by the Office of the Solicitor General shall be transferred to the Integrated Bar of the Philippines Board of Governors for investigation and disposition as provided in this rule except those cases where the investigation has been substantially completed.